Thank you. This will be case 24-056-390, State of Michigan versus Darnell, Rayshaw, Shearer. Counsel's, your appearances beginning with the people.
Judge, good afternoon. Always good to see you. Steve Vincent for the people, please 71917.
Good afternoon, Your Honor. Mark Hart appearing on behalf of Mr. Shearer.
Staff, what's your P number, please?
36686.
Thank you. Do you waive formal reading?
We do.
And standing your client mute?
I am.
Court will enter not guilty plea on your client's behalf. As to bond, please.
Judge, excuse me. My client is 48 years old. He's got a fiance with whom he's got 2 small children. He's been employed at for 9 years now. I can't tell you what the specifics of the allegations are, other than the charges themselves. But it sounds to me as though somebody was saying that there was shots being like fired up into the air or something at my client's house. At least that's my understanding as to what the allegations are.
That looks to be about right.
Give me 1 minute.
Have any requests for bond?
Pardon me?
You have any request for bond?
Yeah, I'm a retained attorney in the case. Obviously, I would be requesting either a personal bond or a very, very nominal bond. He came into my office, retained me. We're getting ready to turn him in.
Okay. And Mr. Vincent.
Judge, respectfully, we're going to be asking for $20,000 cash as surety. And with all due respect to defense counsel, I'm sure he's great at what he does. This has nothing to do with flight. And I can appreciate the fact that this defendant ended up retaining counsel. But what we're dealing with here is not just the shots being fired where there was a shot spotter and police ended up responding and then finding casings, in front of the defendant's house. And then the defendant ends up coming to the door and then the police investigate more and they get a search warrant. I think the rub here is, Judge, the plethora of firearms that were really disturbing when you're talking about what the police ended up finding. AR rifles, 9mm, 22 caliber guns. I think there are either four or five firearms that were found in the defendant's house. And then that's on top of all of the ammunition that was found. And and this defendant's been around the block. He knows better. He has, a prior, I think what I saw, and defense counsel, I'm sure will correct me if I'm wrong. But previously he was convicted of an armed robbery, has a weapons felony firearm conviction. I think that had to do with the same offense. But then speeding up time, most recently, we have a 2017 fleeing felon. Defendant knows he shouldn't be possessing guns. I think it's, a little concerning that we have a shot spotter right in front of defendant's house where casings were found, but then the amount of firearms that were found in this defendant's house with ammunition, we do feel as though, respectfully, we do feel as though this defendant's a danger to the community, and that's why we're asking for the cash. Not flight, just the dangerous component.
Judge, if I might.
Sure.
I believe the armed robbery referenced was from 30 years ago. And there were a couple of misdemeanors between then and the 2017 fleeing and eluding case. But other than the armed robbery, which again was 30 years ago, I don't believe he's got any history of either flight or assault of conduct, although I don't know his entire record.
And I guess my only response to that would be it's ironic. Defense counsel talks about flight because the most recent conviction was for fleeing. And then with that weapons felony firearm conviction previously, the defendant's at least looking at a straight 5 here, whether it's 30 years ago or not. So with all of that being said, Judge, and I do respect defense counsel, we're sticking to our request for cash with some type of monitorization.
Judge, I would also add that my understanding of the case is that at least some of the guns that were recovered from the house were registered to his fiance. I can't tell you how many, but I do know a number of them were. And, you know, it doesn't sound to me as though he's stockpiling guns. You know, when the prosecutor says there were a number of guns, well, there's always a number. The question is how high is the number? And in this case, it's either 4 or 5, as I understand it. So it's not like he's hoarding guns or he's setting up a munitions factory in there or anything else. And,
you know, it's the typical, you know, possession by a prohibited person case, you know, doesn't raise too many eyebrows, but and the 30-year-old armed robbery isn't the biggest concern of mine. You know, I guess, you know, I am wondering why there's an AR-15, there's a 44 caliber revolver, there's a stolen 40 caliber Glock, and one other one somewhere in here. I think there's a 9mm somewhere. But, you know, there's a lot of guns. Apparently the 5.56 caliber shell casings that were found as a result of the shot spotter did match the AR that was found in the house. It's troubling that, and you know, your client I would agree, he's well aware of the fact that he should not be possessing guns. And if his fiance or whoever in the house has guns, then he's got to know that he's got to do something different than what he's alleged to have done here. And you said he's been working where for 9 years?
it's a place called Dubois Chemical.
Okay. Well, it sounds like he's got a steady job and has, to some extent, turned his life around since the 1995 conviction. But he's got to realize that guns can no longer be a part of his life. So, sir, while this case is pending, you are not to possess a firearm or any other dangerous weapon. Is that clear to you?
Say one more time. Yes, it is.
All right. Court's going to set bond $20,000 personal. Again, no possession of firearms while this case is pending, and probably from now on, sir. Next court date is April 3rd for a probable cause conference, April 10 preliminary exam, both in front of Judge Brigh here in 36th District Court. Anything else for this record?
No, I appreciate you hearing me.
Thank you.
Thank you. Thank you, sir.
Good day, everybody.
Yep. And in Wayne County Jail, what's your name, please?
Brigh.
Thank you, sir. All right, this is going to be case number 24L0168SM, State of Michigan versus Ryan Michael Brigh. Counsel.
Good afternoon, Your Honor. Samuel A. Reagan, C-23-157 on behalf of the
And good afternoon, Your Honor. Brandon Bird on behalf of Ryan Brigh. My client waives his right to the formal reading was advised, but we need to interview him, Your Honor. to advise him of his constitutional rights.
Oh, do you need to interview him?
Yes.
I'm sorry.
Lawyer, if the person from district court is appearing on this case or not?
I believe she's just recording it from their court as well. Is that correct? Yeah.
All right,
Yeah.
thank you.
And what is this as a transfer, Your Honor? It says transfer on it.
The entire bench in 25th disqualified themselves, is my understanding of it.
Got you.
Here's a breakout room.
Ms. Shaw,
All right. DDC, what's your name there, sir?
First name Martz, middle name Devon, last name Letler.
Thank you. All right, this will be case 24-056-391. State of Michigan versus Martz, Devon, Letler, counsel.
Good afternoon, Lisa Coyle, appearing on behalf of the people.
and good afternoon, Your Honor. Brandon Bird on behalf of Martz later. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Court will enter not guilty plea on your client's behalf as to bond.
The people in this matter, Your Honor, we're asking for a $500,000 cash bond, tether house arrest if he is able to post that bond, as well as no contact with the complainants in this matter, Your Honor. And the reason I'm asking that such a high bond is because he does have a prior record which involves home invasion first in 2009, a prior gun case in 2014, a CCW felony firearm, as well as a fairly recent domestic violence in 2018. But this is the case where there was a shot spotter run. Officers come to that area within a minute of getting the dispatch. When they come to that area, the defendant's car is parked that way. They asked him to see his hands. He fled. Then they observed him clutching his waistband. But what's troubling in this case, Your Honor, the complainant and the defendant know each other. They're in argument in front of the sister's house. There had been he had been threatening to kill her and the sister earlier that day. That the argument ensues. She says that she's in her vehicle. There is a 9-year-old child seated in the rear passenger seat. He points a handgun at her while standing near her car. She rolls the window up. He begins firing shots. She claims the allegations are he fired at least 5 shots. She said that the bullets were aimed at the passenger side where the 9-year-old was seated. This is extremely serious. He also told her that he was going to bring someone over to beat her butt. So the police respond to the area. They find him. They also find 3 spent 9mm casings from the middle of that street, which would corroborate what she said is shots being fired. And I believe even one of the shots took effect on the rear side of her vehicle. There's a I won't say her name on YouTube, but a witness who told officers that she didn't see the defendant, but she was with the defendant. She did not see him fire a shot, but she did see the complainant's car react in the way as though shots were fired at that vehicle. She also see that he had possessed a gun in his waistband. He dropped her off after he fled the officers and told her to act normal. So there's evidence not only of being a danger, but also as a flight and trying to conceal himself from being apprehended. Your Honor, I believe that he is not only a danger to the complainant, the 9-year-old, although the complainant are all family, hesitant to prosecute. At this point, it's not her case. This case belongs to the state of Michigan, and she is thus just a witness. He poses an actual danger and a flight risk.
Thank you. 1 second. Let me put this breakout room together.
Good afternoon, Your Honor.
Good afternoon, counsel. I understand you're going to do the interview with
Wayne County?
the gentleman in Wayne County? Yeah.
Yes, Your Honor.
Yeah, he not introduced.
All right.
Sorry, this guy said he.
Okay. All right, Mr. Byrd.
Yes, Your Honor. 34-year-old lifelong resident, 2 children, lives with his mother. He indicates to us that he's not on probation or parole and doesn't have any pending cases. Works, he is employed. And what are your work hours, Mr. Later?
Work hours are from 7 in the morning till 5 in the afternoon.
What days?
Monday through Friday, and I also work some Saturdays.
Got you. But he's well below the 200% property guidelines, and that's even before including his family size, Your Honor. So any amount of bond would be like a remand for him in this matter. I do understand these are very assaultive allegations, but he's still cloaked in the same presumption of innocence as everybody else that walks through this door. So respectfully, we're going to ask this court potentially for a personal bond, but I know the court may not be inclined to a personal bond in this matter. So a reasonable or low 10% bond seemed fit by the court, even though that would be like a remand, Your Honor.
Thank you. One moment. So it appears both the complaining witness and the independent witness identifies the defendant as the person doing the shooting. Multiple cases are found. And then you've got this 9-year-old in the car. You know, based on what I've got in front of me, I do find that the defendant poses a severe risk of harm to the community and to these complaining witnesses specifically. So here's what we'll do, sir. While this case is pending, you are not to possess a firearm or any other dangerous weapon. You're to have no contact with either of the Williams family members. Should you post bond, you'll be on GPS tether on house arrest. Fine will be set at $500,000 cash or surety. I'll give you a bond redetermination hearing Wednesday, March 27 in front of Judge McConico. Probable cause conference is April 3rd and preliminary exam is April 10. Both of those are in front of Judge Jefferson here in 36th District Court. Thank you, sir. Step aside.
Okay, thank you.
And if you could just tell me that bond one more time, please, Your Honor.
$500,000.
Joshua George Hart.
Thank you, sir. This is case 24-056-392, State of Michigan versus Joshua Jordan Hart, counsel.
Thanks, Judge Stevenson, for the people.
Thank you, Your Honor. Brandon Byrd on behalf of Joshua Hart. Our client waives his right to the formal reading, was advised his constitutional rights, so will stand mute.
Equivalent or not guilty plea on your client's behalf as to bond.
Judge, respectfully, even with the ACLU agreement in place, I think I could make a justifiable argument here that the defendant's a danger. At least he posed a danger to the community. I mean, What we're talking about is open bottles of tequila and mushrooms, the psychedelic mushrooms, and guns. And then we have a defendant who's, you know, in the driver's seat of a vehicle. Judge, I think the psychedelic mushrooms and the drinking aspect of it, those were citations that the defendant's going to have to deal with. I don't think personally it's a good mix, but with all that being said, Judge, no priors. I'm going to pick my battles with you this afternoon. Not going to be objecting to personal bond.
And I'm not going to waste the court's time with explaining the good things about this young man, Your Honor, but I'm no objection to a personal bond.
So, anybody know if there was a OUI investigation done and what the alleged blood alcohol would have been?
Judge, what I ended up seeing, based on my reading, is that there was this open bottle. I don't know if there was an investigation that was performed. And if it is, it's still ongoing. There's nothing conclusive. I personally don't think it's a waste of time to talk about everything that was involved in this situation, because if he did have priors, I would have been asking for cash. But with all of that, I'm going to digress.
Okay. All right, sir, while this case is pending, you are not to use alcohol, marijuana, or any illegal drugs. Is that clear to you? Additionally, you are not to possess a firearm. Is that clear to you?
Yes.
The court's going to put you on an alcohol tether while this case is pending. Court will set bond at $10,000 personal. Happen to agree with Mr. Vincent that a combination of alcohol, hallucinogenic mushrooms, and guns is probably not the best mix.
I do understand, Your Honor, but permission to speak first.
Go right ahead, counsel.
I do understand, but it's no charges. It's no charges that he was even under the influence of any of those things, Your Honor. The only charge that we have in front of us is to carry a concealed weapon and to open alcohol. We don't. I'm pretty sure. The police usually are pretty thorough and the prosecutor on charging everything they can on somebody. I don't even see where it said where the defendant took a breathalyzer, where they smelled alcohol on his breath. We don't even know if those bottles and those mushrooms in the car were his. But he is being charged with them, and they are. And that is, and we only got the open alcohol on the complaint, but we have nothing. We have nothing in this record that tells us that he needs an alcohol tether. We don't even have anything in this record to ever tell us that he used alcohol. Period, Your Honor. So respectfully, we're just gonna ask to take away the alcohol tether. Like I said, the police don't even say they even observed him intoxicated. They don't say they observed him to seem like he was ever off of a hallucinogen or mushrooms at all. It doesn't even say that he was using those things, and we don't know. We don't even know if he uses those things or if those were his in the beginning. And he has a right to his day in court for that. But it's nothing in the complaint that warrants an alcohol tether besides having an open bottle of alcohol in the car, in which we don't even see an indication that he was ever drinking that alcohol.
I mean, I could say a lot, but I won't.
No, please don't. I appreciate your argument, Mr. Byrd. Alcohol tether will stay on.
Thank you for hearing me out.
And all right, 10,000 personal. Next, did I give you your date set? April 2nd for probable cause in front of Judge Robbins. April 9th for preliminary exam in front of Judge Jefferson, both here in 36th District Court. Thank you, sir. You can step aside. All right, Mr. Bright. And your name for the record, please. Oh, you're muted on your end.
Ryan Bright.
Thank you. This will be case 24L0168SM, State of Michigan versus Ryan Michael Bright, counsels.
Samuel A. Ragnan for the people, Your Honor.
Good afternoon, Your Honor.
Oh, sorry. Thank you, Judge.
Sorry.
Thank you, Michelle.
Good afternoon, Your Honor. Jessica Scheib on behalf of Mr. Bright, who is from a reading understands his constitutional rights and stands him.
Court will enter a not guilty plea on your client's behalf. As to bond.
Yeah, the people are going to ask for $15,000, 10% bond. He's able to post that bond. We're asking for GPS tethered with home arrest. This defendant, Your Honor, back in, I believe it was November 28, 2023, was placed on probation in 25th District Court. 28th District Court, I apologize. And the conditions were very direct. And they were that, number one, he would have no contact with any employee, representative, official, or 28th, 5th District Court, or any Lincoln Park department or office, except during normal business hours for business purposes only. No contact with Lincoln Park City Attorney, except during business hours. On December 10th, violated those provisions of his bond by sending an email to a person that worked there, plus the city attorney. The email stated that the city attorney was doing damage to the clients, it caused a hard time judging reality. I'm sick of living in fear. It was somewhat, it goes on and on to list multiple things that apparently the email city attorney was not doing. And it was somewhat, we believe, threatening, Your Honor. On February 4th, an email was sent again to the city attorney, and it says that, I don't know what you want to do, but one of us is going to have to leave. My last week of dealing with you. I hope blank is proud of you. He's referring to a family member of the city attorney by the first name. So a very frightening situation. This defendant, Your Honor, he doesn't care about what he's ordered to do or what rules he's supposed to follow. What happened, Your Honor, is that he then contacted, on January 30th, he went into the Lincoln Park Police Department to talk to the police about what his wife's child's mother was doing, which they obviously don't have any control over. But however, he then had sent an email communication on February 2nd, indicated that he never violated the orders of probation by sending emails because the city attorney didn't respond and tell him not to. Now, prior to this, Your Honor, occurred back on I think it was December 10th, 2023. On March 6th, 2024, he was charged with police officer fleeing 4th degree, officer assaulting, resisting, obstructing, 3 counts of that, Your Honor, and then charged 3rd offense because he's formally convicted of home invasion 2nd and also of possession of 25 grams. He has multiple convictions that go back to 729-4. Home invasion in 729-4. I won't get into the control substance. Home invasion 12309 NCCW, and then in 12-6-22 convicted of assault and battery. 9-8-23 charged with stalking, and then it was subsequently dismissed on 11-28-23. But, Your Honor, it's a very frightful situation with this defendant. He thinks he can terrorize people to do it. And what he did to the police officers just recently, dragging him through his house when they're trying to arrest him multiple times, wouldn't stop, is just assaultive. So We feel that this defendant is a danger to the people at the court system, number one, to their family, and any employees or people that he may have connections to that courthouse. So we're asking for the $15,000 10% bond with GPS tether and home arrest. Thank you.
Thank you.
And Mr. Brigh, I do see your hand up, but at this time, I'm going to advise you of your rights to remain silent. Don't say anything at all at this time. Let me argue bond for you first. And then if you have questions about your bond or your court dates, and you can go ahead, but I want you to be careful what you say on the record because it's all being recorded. We have prosecutors on from different districts as well. So I want you to be mindful of that before you say anything. Your Honor, Mr. Brigh is a lifelong resident, and this is charged as a misdemeanor, allegedly from December 2023, not entered until February 4th. And that is correct. He is being held, and he does have cash bonds that he cannot afford. He's been in custody since March 7th. He's asked us multiple times to ask the court for a speedy trial because they keep holding him up on a lot of matter on these matters. He's never been arraigned on this matter. He understands no contact, and I'm respectfully asking the court to consider a nominal bond here, Your Honor, so he can get credit for time served. And the people themselves were asking for a 10% bond. So I'm asking for a $100 10% bond or $1,000 10% bond. Your Honor, any bond amount is going to be unaffordable. This is a misdemeanor since February. So respectfully asking the court to consider a nominal bond so he can get credit for time served. I don't believe the tether is necessary. He is being held on a $25,000 10% bond that is unaffordable to him, Your Honor.
Thank you, counsel. One moment. You know, these allegations are troubling, especially when he gets into making mention of someone's daughter. You know, it's whatever Mr. Zelenak chose to do for a living, he takes on that responsibility, but daughter is completely off limits to allegations of such behavior as this. So there will be a GPS tether house arrest if Mr. Bright posts bond. And bond will be set at the people's request at $15,000, 10%. One moment for your next court date. Next court date will be a bond redetermination hearing in front of Judge McConico here in 36th District Court on Wednesday, 3/27. And Madam Clerk, these other two dates, are they here or? Okay. And who's the judge on? Oh, McConico. Okay, and further dates will be probable cause conference April 3rd at 10 a.m. and preliminary exam April 10th at 10 a.m. Those are also in front of Chief Judge McConico here in 36th District Court. Anything else for this record?
Your Honor, I'm sorry, but this case is for a misdemeanor, correct?
Yes.
So it should be in front of Judge Bryan.
No, I think because of the unique nature of it, the chief is taking the whole case.
Okay, so April 3rd, and I'm sorry, what was the next date?
April 10th.
Okay, thank you, Your Honor.
Looks like your client has his hand up, Ms. Shives.
Sir, you do have a right to speak, but as your attorney, I'm going to advise you to be careful with what you say on the record, and I would advise you to not say anything at all. But if you want to speak, that's your right. But just remember that it's all part of the record, it's all being recorded, and you have prosecutors on from this district as well as the 25th district. So I would just be cautious and mindful of that.
I understand. I've already been arraigned on these allegations in Romulus is where I'm confused about, where he's the complaining witness for stalking. So I don't know what's going on with this. I got a $300,000 10% bond in Romulus on these allegations already with him, the witness. I don't know.
And,
So can you please shed some light on that? I don't know.
if the representative from 25th District Court has any indication, is this a separate case or what's going on with the Romulus one?
Yes, this is a separate case.
With the same
Thank
witness?
you. Apparently so, sir. Okay. Anything else for this record?
Nothing further, Your Honor.
Nothing further, Your Honor. Thank you.
Okay, thank you. Thank you, sir. Have a good day. And thank you from 25th District Court.